Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book which has come to us from Oxford University Press, and the book's title is Antitrust and Patent Law. This book over here. It's been written by Alan Devlin, and the consultant editor is Lars Kjolbye. Apologies for mispronunciation, Lars, if I got that wrong. Now, Elizabeth and I looked at this book and had a chat about it, and the end product is a title for our review as follows: Helping Antitrust Practitioners Solve Competitively Sensitive Business Issues in the New Economy. And it's very relevant, of course, at the moment. I record this after the historic vote to leave Europe by Britain, so it's new territory for all concerned. Let's look at the book first. It's from OUP, as I said. There's the front cover, and then there's the spine. There's nothing on the back. Now, the book is a hardback. It runs to something approaching just under 500 pages. There's the index at the back. It's a very standard, very good index. It's done referring to paragraph numbering, and you can see the paragraph numbering is listed on the sides there, and there's a very substantial amount of footnoting, as to be expected with any publication of this nature by OUP. There's the front cover, and then after that there's a nice dedication which I always like to show so you can see who it's dedicated to, and then there's a table of contents as such. You see split into various parts, 14 chapters with a concluding chapter for chapter 14. Then you've got a table of cases, and then after that just a short amount of table of legislation there, mainly European Union guidelines, I hasten to add. Then part 1, introduction and recent developments, so it goes straight into the Antitrust and Patent Law. There's an introduction there and so forth, and then it runs through, starting off, antitrust lawyers have an enviable craft. Absolutely so. I think this book is an enviable craft as well. It's an excellent book. This is what we say about it anyway. Competition lawyers, especially those specialising in antitrust issues, will welcome this new work of reference published recently by Oxford University Press. The foremost challenge facing such practitioners, says author Alan Devlin, is, quote, the difficulty of navigating the patent-antitrust intersection, which is the object of this book. And he succeeds, of course, with his task. The intersection, then, between patent law, or patent law, and antitrust legislation is closely analysed in this text and explained with clarity, pointing out more than a few fundamental truths. The introduction to the book's first section, for example, refers to the intricate relationship between competition law and the patent system, adding that policymakers increasingly call on competition law to ameliorate problems that are a function of patent law, making it important for practitioners in this space to understand both antitrust and patent law at a substantive level. Yes, the book can assist the occasionally bemused practitioner with the task of advising clients, but equally it offers the wider, more analytical viewpoint that is essential in global business. There's another quote here. Antitrust patent law is an international affair, says the author. Therefore, the book explores the world's most important competition regimes, namely the United States and the European Union, and in so doing examines their rules and policies and the relevant economic principles that inform them. As there are notable differences between the antitrust regimes of Europe and America, the book explains why these distinctions matter, particularly for certain clients and their advisors. Very topical, of course, as I say, at the moment in July 2016. But as the author also points out, the book is aimed not merely at advisors, but at a wider audience in search of insightful commentary on the theory, practice and evolution of competition law in the technology sector, including biotechnology, notably the life sciences. And we're reminded here, for example, that competition law is a full-time occupation in the pharmaceutical industry, and of course that's a very important point to make. Thus the book illuminates the symbiotic relationship between technology and the law and the advancement and evolution of both. To wit, the one can't do without the other. As the new economy has mushroomed, says the author, so too has the heterogeneity of innovation and the strategic importance of patent holdings. And the lodestar of antitrust, he adds, is a consumer welfare regardless of whether a digital application or a steel mill is at issue. And I think that's certainly a very important point in our modern industrial society. Underpinning all this is a complex jurisprudence to which the book contributes a much enhanced understanding. Easily navigable, it excels as a research tool too, with extensive tables of cases, mainly from the EU and the United States, and of course EU and US legislation. Now, I don't know where we're going to be in the future, obviously, but for the short term at least, all this is wholly relevant and current. Let me conclude by saying that practitioners involved with imparting reasoned, well-considered and authoritative advice within the context of the new economy would do well to acquire this book. Students, academics and policymakers will also benefit, we think, from what is an absorbing, in-depth analysis of a complex area of law, ever subject to the vagaries of rapid and continuing change. And the publication date is cited at 2016. Let's just have another look at it again. There's the front, and then we just go to the back, and you can see very quickly the detail in the index. As I said, the index does actually have paragraph numbering, so you can find things very, very quickly. Closing thoughts are always worth reading, just to get an idea of where we are. It's a critical field of public policy, according to the author, and it's going to remain so, I would have thought, with the way things are going. As I say, let's just look at the front of it again, tables of cases there, and then if we open it in the middle, you can see a whole range of different subjects covered. Antitrust issues surrounding open and closed systems, for instance, is one chapter there. And again, you can see paragraph numbering and the useful footnotes. Well, thank you to Alan Devlin and his co-editor, Lars, Kjolbye, and of course to OUP for an excellent publication, which I know everybody involved in this field will find extremely helpful. Thank you to all. Do have a look at our review on the journal, in the journals and on the web. Thank you very much. Bye-bye.